our broadcast today. My name is Cindy Speaker. I have with me today Disability Representative Noelle Black of Gardberg and Kemmerly. Noelle, how are you?
I'm good.
Excellent. Well, it's nice to have you again.
Yeah, it's nice to be here. Thank you.
Yeah. Well, we're going to talk a little bit about, we're going to talk again about Social Security disability, which is your area of expertise. We're going to talk a little bit about how employment history affects a Social Security disability case. So initially, tell us a little bit about how previous jobs would affect someone's case.
Well, when you file for Social Security disability, not only do they have to consider if you're disabled, but they also have to look at the work that you've performed and if you can still perform that work. And then they also have to look and see if there's other jobs that you can perform out there in the national economy. So there's a lot of questions and issues that can go into deciding, if you're disabled or not.
Okay, and how do they figure that out?
Well, Social Security has to consider the work that you've done in the past 15 years. And so that work had to be performed at what they consider substantial gainful activity, which means you had to have made enough money, had to perform the job long enough to learn it. And for 2019, that monthly amount is $1,220 a month. So if you perform a job for 6 or 8 months, a year at over $1,220 a month, then that can be considered past relevant work. And we have to look at all of those jobs that you performed at that level.
Wow. Well, let me ask you this. Okay, let's suppose we have somebody, it's a construction worker, he's disabled, he's filing for disability, but maybe a few years in the past he worked as a security guard for a lesser amount of money. Is that going to negatively affect him?
Sometimes it can.
Okay.
When we go to a hearing, which is where most of these types of decisions are made on the vocational abilities of a claimant, they may have gotten hurt on the job. Maybe they are seriously hurt and they can't do the job as a construction worker anymore. But if the work that they've done, like I said, in the past 15 years is of a construction worker and a security guard, the judge has to decide if they can't do the construction worker, that doesn't automatically mean they're disabled. Okay. They also look to see if they can do any of the other jobs that they performed in the past 15 years. And if one of those was a security guard, that's not quite as physically demanding as a construction worker job.
Right.
So all of those jobs have to be considered. And sometimes, depending on what your limitations are, you may not can do the construction work, but you can do the security guard job.
Yeah. Let me ask you again, did you say that their line in the sand is about $1,200 a month?
$1,220 a month is
which
what
is not
Social
much.
Security, no, but that is what they call substantial gainful activity. So if you are making that much money, then they consider you gainfully employed.
Okay, so that could really, what about if somebody had a whole lot of part-time jobs, but they made the $1,200 a month in their part-time jobs? Are they all factored in?
Well, it kind of, the same rules kind of apply. Social Security, when determining if you can perform any job, they have to consider a full-time basis for those jobs.
Oh, they
However,
do? Okay.
Yes, they can't say that you can go back and do another job part-time. They have to say that you are able to perform a full-time job. However, when looking at past work, I see so many, and I guess it's because of our healthcare regulations that we have now, so many employers only employ people for that they stay under that 32 hours a week so that they don't have to offer benefits to them.
That's true.
However, if you make $20 an hour at 32 hours a week, you're going to be over that $1,220 a month. And that work can be considered past relevant work, even though you only worked part-time for a couple of years, because you made gainful activity on the job.
This gets complicated.
It can be very complicated. And, that's one of our areas of expertise, and that's where, we can come in and help with that.
Right. Well, how is it that the Social Security Administration determines if someone is disabled and therefore qualified for benefits?
Well, they have what they call 5 steps to the sequential evaluation process. The first one is, are you working? And if you're working presently, over that $1,220 a month, you're not disabled. Second is, do you have a severe impairment? And that is any impairment that limits your ability, causes severe limitation in your ability to perform work limitations. The third is, do you meet certain Social Security listings or rules? And those are based on specific impairments, and there's a lot of those rules and regulations and listings for that. It's not something your general population is going to know, so that's something that we look at on each of our cases. You can't lose at step 3, but you can win at step 3. If you do not meet any of those specific rules, then you go to step 4, and that is, can you do any of the work that you've done in the past 15 years? Is there any of those jobs that you're able to perform? And if we get past step 4 that you cannot perform any of that work, then we go to step 5. And that is, can you perform other jobs which exist in the national economy in significant numbers based on your limitations? And so that is basically the 5 steps. And if you can't perform other work, then you're disabled.
Okay.
So it's kind of a
it's
long
very complicated
process. Yeah.
Yeah, it really is. All right, let me ask you this. So can your firm help them figure out what jobs they may be eligible for? Because and the second part of that question is the Social Security Administration going to listen to your recommendations or their recommendations for that? Or do they completely make their own recommendations?
Well, it just depends. It's not that they say necessarily that, Cindy Speaker can go and do a job as a telemarketer or something like that. But they pose it as hypothetical individuals with the same limitations as you have. So, we are not vocational counselors. We can't tell you what jobs you are or not able to do, but it is all based on your medical records and what your treating physicians say. If we get a statement, and we typically always try to get a medical source statement from a physician, and if that medical source statement says that, you're only allowed to sit 2 hours a day, and you're only allowed to stand 2 hours a day, you can't lift more than 10 pounds, then, at a hearing, which is where most of these decisions, as I said before, are made, there will be a vocational expert that testifies at that hearing. And so we pose questions to that expert based on the limitations that are in your file. And then that expert is the one that tells us, well, with those limitations, yes, this person would be able to do their past work as a construction worker or security guard, or no, they would not be able to do that work. And then, they may also say they can't do that work, but they can do, another job. Or they may say, based on those limitations, there's no work. No job exists in the national economy that someone can do that can only sit 2 hours and stand 2 hours. But that's only a 4-hour day.
Yeah.
They have to consider an 8-hour work day.
Okay. So really, to work through this, it really sounds as if you need an attorney on board to help. I don't see how the average person, I don't think I couldn't figure it out. It just sounds like there's so many moving parts to this whole process.
There is a lot of moving parts, and, there are people who can go in and get approved, and they may have a judge that's sympathetic and, get approved without a representative, but it really is rare case scenario. And most of the time when you walk into a hearing and you don't have a representative, the judge is going to advise you about right to representation and really, suggest that you find representation and someone to help you to maneuver these things, because, you don't know what questions, and most of the time these claimants are not going to ask a question to the expert. And if the judge doesn't ask the question that supports your case, then, you're not going to win that case. And that's the difference that we can help in making that.
Right. Noelle, how can someone reach out to your firm for help? Because I know you handle a lot of these.
Oh, yes, we do. Yeah. It is 251-343-1111. They can call us, or 1-800-332-1529. They can also find us online at www.gardberglaw.com and call the office and let us get on board and start helping you with your case before you get to that hearing level, before, all this information is too much for you to handle.
Right. Well, listen, thanks for being with us today.
My pleasure. Thank you.
Yeah. To those of you that are watching either live or by replay, if you have questions or comments, you can put them right on this page. Also call the office, check out the website. There's lots of resources there. Whatever you do, if you're in this position, you're disabled, you're trying to get benefits, it just sounds like it's really a no-brainer to get an attorney involved. So your goal, and I know, and my goal just in listening is to help people. You want to help people get the
Exactly.
benefits they deserve. That's the bottom line.
Exactly. That is the bottom line.
Thanks, everybody. Have a great day.
Thank you.